Welcome back. I hope everyone enjoyed their lunch. I know it was short, but we have a lot to do. So I'd like to welcome Professor Julia McLaughlin. She's here from at Florida Coastal and specializes in juvenile law issues. She's going to share with us information about unaccompanied and undocumented, the substantive due process and equal protection rights of minors.
Good afternoon, everybody. Nice to see you. I see some familiar faces and many people here from the community, so that's fantastic. I wanted to begin by, of course, thanking Betsy for putting on a great program for us, and to remark that this morning, listening to the presentations, although we had the theme of frustration, I also felt very energized by the possibilities for reform and change. And I think that there is great work to be done on behalf of parents' rights in the area of dependency work, great opportunities for bringing this type of perhaps restorative justice into our high schools to help keep our teenagers out of the pipeline that can lead from school to prison, and of course work that we can do to reduce the number of direct filings when appropriate to give our minors a better chance at finding happiness in adulthood outside of prisons. So today, in my talk, I wanted to call attention to another problem that has been in the news, and that is this issue of what has been referred to as a surge of undocumented minors at our border. And as I began to look into this in order to write a law review article about it, I realized that the rights of our undocumented minors are controlled largely by the immigration law, which is enormous. But there's one small provision in the William Wilberforce Trafficking Victims Protection Reauthorization Act, which I will refer to as TIPFRA throughout this, so we don't get slowed down by that big long name. And this provision was surprising to me because it treats children from Mexico differently than children from all other countries. And the reason is it has a provision that talks about children from contiguous countries. And so, of course, we don't have a lot of Canadian children coming to cross our border, but we do have a tremendous number of children coming from Mexico and from South America. And I was surprised that the statute contained this expressly discriminatory provision that really is related to national origin, which when we think about our 14th Amendment and our 5th Amendment, we believe that the country should not be discriminating again based on national origin. But I found out quickly in my research that immigration is a whole new world and that these constitutional protections have to be earned by individuals who are seeking to enter the country, and they are not automatically available to them. Personhood is not afforded to many of our immigrants under the Constitution. So I'm working really hard to make an argument that the children who are crossing our borders are entitled to greater and broader protections, and that this right can be related to our Constitution. So my goal is to show you what the problem is all about, to introduce you to TIPFRA, to take you through a couple constitutional arguments that I'm making in my paper, and then to see if I have convinced you that indeed we should have one process which fairly protects the rights of undocumented and unaccompanied minors rather than having separate but equal tracks. Separate and unequal would be my, separate but equal, but my view is they're unequal tracks. So where do I get my information? Much of it is coming from the reports that have recently been written by nonprofit organizations and by NGOs. Some excellent work was done by the Appleseed Mission that published a report in 2011 focusing specifically on unaccompanied Mexican minors. There's also very good work done by Vera with respect to some statistics and reporting regarding how minors are treated at the border. And the MacArthur Foundation also has an excellent report. So I'm relying upon the reports that have been published recently regarding what's happening at our borders to our minors. This is what SURGE looks like. It looks like undocumented minors in many, many numbers being placed into detention for sorting. When you read about this, it looks like they are often held in very cold conditions, refrigerator-like conditions. They are deprived of food and water during this short period of time when they are being sorted. It suggests to them that the best thing they could do would be to get out of that type of detention. Once the minors are sorted, we'll talk about that in a moment. We can see this problem did not really exist in 2009 for children from Guatemala, El Salvador, Honduras, but that we always had a flow of unaccompanied children across the Mexican border. And it makes sense, it's a shorter trek. Perhaps these children lived closer to the border. But we've seen a huge rise in children from Central America trying to escape poverty, trying to escape violence, trying to escape the problems associated when gangs are controlling rather than the government with respect to where these children live. So what are these numbers? The final number that we are left with is 68,541 minors were taken into custody at the southwest border during the fiscal year 2014. That's an incredible number of minors. It is up 77%. It is a group of children, for the most part, they are not accompanied by a parent. And this has created truly a crisis at the border. The Border Patrol is trained in law enforcement. They wear guns, they have badges, they arrest people and put handcuffs on them. They are not prepared for dealing with minors. We're also seeing that the age of the minors crossing the border is much younger. We have individuals who are 12 and 13 and 14 years old in groups, but unaccompanied by a parent who are crossing the border. And our Border Patrol is not prepared to deal with children in this manner. The Mexican unaccompanied minors make up approximately 23% of the number of kids taken into custody. Around 15,000 Mexican minors, and then a little bit higher numbers for those from Honduras, Guatemala, El Salvador, who are leaving that triangle, that northern triangle in Central America, where there is a degree of poverty and lawlessness that clearly they feel taking the chance of traveling up through Mexico is better than remaining in their home circumstances. The legal issue arises under the statute TIPFRA. And as you can see, the child is immediately screened, and the Border Patrol determines, is this child from Canada, which is not particularly relevant at all to the statistics, or Mexico? If the child is from Mexico, the child is sorted and goes off into the group which is on your right. If the child is not from Mexico, the Border Patrol has to notify the Department of Health and Human Services. And these children are turned over into a system that has a focus on child welfare. It is not a fantastic system. It is not funded beyond belief. It has a myriad of problems, but it is a system designed to deal with minors. When we deal with the children who then are left in the custody of Border Patrol, they are handled on an expedited basis. These minors are moved through the system extremely quickly and in many instances returned on the same day, held in those very awful conditions that we see, interviewed in a summary fashion, and returned. So my question is, why aren't more of these Mexican minors making it into the Department of Health and Human Services custody? Why is it, if the department, if they are such a large percentage of the entering juveniles, 23%, only 3% make it into the Department of Health and Human Services, get onto the side where there are services available, a guardian ad litem, the potential, if not guarantee, for legal representation? What is going on? And my research has indicated that what is happening is that under the 235A2 approach, the case-by-case screening that is done by Homeland Security, done by the Border Patrol, is not obtaining the goal that Congress has in mind. It is not securing the rights that Congress intended, and in fact is creating a revolving door where many of these children from Mexico are repatriated across the border, not far from the United States border, and perhaps try to cross again without being detained. So Section 235, which is the section that applies to Mexican minors, has 3 questions that the Border Patrol is obligated to screen for. And if any one of these is deemed to be a no, that is, there is a problem here, the Border Patrol is obligated to transfer custody to the Department of Health and Human Services. The 3 questions are screening questions. The first is to screen for trafficking. We've had a lot of focus on trafficking, the idea that a child or a person who may be in some way vulnerable has been preyed upon and forced or coerced into some type of labor or the commercial sex trade. So we have an obligation that Congress has created to determine whether there's any credible evidence that the child has been trafficked, that is brought it across the country by a trafficker who then intends to have that child either work for him in the slave trade or even in the fields, or whether that individual will be at risk of being trafficked upon return. So this is a very specific, legally dense question that the Border Patrol, who are law enforcement agents, are now left with the screening obligation to make that determination. Not a lawyer, not a social service worker, no one other than the Border Patrol officer on duty whose obligation it is to conduct the screening. The second question is whether the minor has any type of an asylum claim. And this is an enormous right that has been bestowed upon all individuals who are seeking entry into this country. This idea that if you are in fear of persecution, the United States will recognize you as a refugee and will not return you to the country where your life is in danger. That is the second screening process. Once again, a very specific, legally dense question that the Border Patrol has the obligation to make that determination on behalf of Mexican unaccompanied children. The final determination is whether this child is really old enough to make an independent decision. If the minors are not, cannot make a viable claim for asylum, cannot make a credible fear claim, the third decision the minor is faced with is whether to withdraw their application, because that's what it's treated as when a minor is taken into custody at the border. It's as if they've applied for citizenship, but they don't have the proper documentation. So their application will move through the system. They would have a right to get in front of a judge. Clearly, they would fail because they don't have any valid basis to be here. So they can withdraw their application for admission to the United States. And this is what happens in, I would say, close to all of the Mexican cases where the undocumented minors are taken into custody without a parent present. They choose voluntary departure. And what that does is it puts them back on the other side of the Mexican border without any support from the United States in terms of claims they might have. The Mexican child welfare system is not as well developed as ours, and often these children are then in Mexican custody for a couple days and sent back home, and in many instances they try and cross the border again. So this is the protection that is available for Mexican unaccompanied and undocumented minors. They often withdraw their petition to their application to come to the United States. They're placed on these vans or buses that drive back and forth the border every day, and they're repatriated on the Mexican side of the border with Mexican child welfare workers. So why am I worried about this? Why does this bother me? Here at least is a process. It's 15,000 children a year. It's a huge burden for the United States. Well, when we read about the treatment, we see that the screening process raises very grave concerns. There are complaints right now that have been filed regarding abusive, physical and psychological abusive treatment. That these children are then put into the types of detention facilities which do not meet the minimum standard that they are entitled to under existing federal law. These border and patrol agents have insufficient training with respect to even what the screening process is about. In one example, an officer indicated that he only screens for asylum and trafficking if the child doesn't agree to voluntary return. So they swap the whole process and give the child the voluntary return form. And if the child says, I want to stay, I don't want to go back across the border, that's when the screening occurs. And that's not at all what Congress intended or what our duty to the international community requires. The screening forms themselves are deficient. They're often in English rather than Spanish. In many instances, the Border Patrol have already filled out the form, checked the voluntary return box, and the minors are just told to sign the paperwork. So that we have huge procedural problems at the border with respect to dealing with a large number of children. And my concern is really for those who fall into this very summary process of screening and expedited return. So what's so much better for the kids from other countries? What is it that I think would benefit Mexican minors? As I said earlier, they are transferred into the Department of Health and Human Services, which became a part of this process when the Department of Homeland Security was formed. That has to happen within 72 hours. They are interviewed by trained Department of Health and Human Services individuals with a background in providing social work services. There is a duty to provide pro bono counsel for these minors if possible. The statute does not demand representation for children because of the cost involved, but it does require the best efforts to provide counsel for these children. They are entitled to a guardian ad litem. They are entitled to a non-adversarial asylum screening. Again, before an individual trained in that capacity. They will get a pre-removal hearing before an immigration judge if they do not state a basis for asylum or for trafficking. And while they're here, they get services. They get medical services. They are placed in a least restrictive environment. Many are placed in foster care. And there is at least a slowing down of the deportation process so that we can find the minors that truly are in danger if we return them to their home country, and many are fleeing life-threatening circumstances. And we provide a uniform treatment procedure for all minors without discriminating, I would say arbitrarily, based upon their country of origin. So the problem that we face is that individuals who are seeking to enter this country without documentation have very few rights constitutionally. So in order to make a procedural due process order, I have to find a fundamental right, a right of core importance for these children, that their life, liberty, or property rights are somehow harmed by the deprivation of the process that Section 235 affords. It's an uphill battle. There, you will read case after case. There is plenary power. All the power of Congress is at its zenith, at its apex in power with respect to controlling immigration policy. This is because Congress has the obligation to secure our borders. There are national security concerns. There are just huge deference to the statutes that Congress passes in the immigration area. There's also broad executive power for the president, which we know there's lots of fights right now about DACA, about the Dreamers Act, how much power the executive has to then carry out the law that Congress has enacted. So this is an uphill battle, to say the least. Another problem that undocumented Mexican minors face at the border is the entry fiction. And if you haven't taken immigration law, this may be quite foreign to you. If you are somebody entering the country and you're not a United States citizen, you are an alien under our vocabulary. If you have entered with a valid visa, with valid documentation, Or if you have successfully crossed the border and you have not been taken into custody at all, you have not been arrested, you are deemed to have entered the United States. You stand in the position of a person, as do other United States citizens. However, if you are taken into custody on the threshold of entering, if you are arrested and you do not in some way avoid Border Patrol, avoid being arrested, your rights are much less robust. So this is the framework of federal law, the United States Supreme Court interpreting our Constitution and our immigration statutes that we are left with. I was hoping, as I read more and more recent cases, that I would see this entry fiction fall away, because it doesn't make any sense to me that somebody who illegally or without documentation successfully enters and somebody who is taken into custody immediately has fewer rights. It made no sense to me. But the Supreme Court has recently, as recently as 2001, upheld this fiction. And it says the court says certain constitutional protections which are available to persons inside the United States are unavailable to aliens outside the United States. And this outside the United States adopts the entry fiction. So we have many fewer constitutional rights, and we are struggling with the question of, well, where can we find a hook? Where can I find a constitutional right, a core right that Congress has given to aliens, so I can move forward with my constitutional claim that the rights are being violated? We find that in the federal conventions and statutes that have been signed and enacted in the United States. In 1968, the United States signed the United Nations Protocol relating to the status of refugees, which obligates us to do our part in terms of providing safe harbor for those who are persecuted in other countries. It became law in the United States in 1980. Congress passed the Refugee Act, and it does require us to provide safe harbor to those who can assert a valid asylum claim. So we've seen despite the entry fiction, some federal courts have been willing to recognize a fundamental right to claim asylum. So even if these individuals are taken into custody when they're stowaways on the boat or right at the border when they don't have documentation, some federal circuits have recognized a fundamental right to exercise your right for a hearing. Not that you will get asylum, but that your asylum claim will be heard. And that is the fundamental right that I want to assert on behalf of the minors who are entering the country. Those who are not from Mexico have this right. It's protected within the TIFRA statute. It is only as to Mexicans that this right is not protected. Mexican unaccompanied, undocumented minors. So the other important part of TIFRA is that it requires that removal piece of paper, right? That voluntary departure paper should be knowingly and voluntarily signed. Your rights should be knowingly and voluntarily waived. And that also is not happening. So when we do a procedural due process analysis, we want to look to Matthews v. Eldridge and apply the balancing test that the Supreme Court has approved. And I believe that when we do this and we look at the interests at stake, the risk of erroneous deprivation, and the government's interest, it's clear that more procedure, better procedure is required. The interest at stake is the interest to be free from bodily harm through forced return to an unsafe setting. The risk of erroneous deprivation can truly be life-threatening if we return children to sex trafficking, if we return them to persecution in their country of origin. And the value of additional safeguards is sort of set out beautifully in the statute with respect to the safeguards afforded to minors from other countries, that there is value to these additional procedural safeguards. And once again, the same slide, the importance of getting into the Department of Social Services, getting the opportunity for a guardian ad litem, potential pro bono representation, and a hearing before a judge if you get to that process, and with counsel you are able to assert that right. So what's the government's interest? Well, certainly the government has a huge financial interest at stake. That's one of the biggest, I think, roadblocks to congressional approval of representation for minors in immigration proceedings. The very cost is extremely prohibitive. And so I guess my response to that is, well, this is a smaller group of perhaps individuals who, and I'm not asking for representation in every instance, I'm simply asking for a fair protection of their right to an asylum hearing and their right to be screened for trafficking, and not to have children who are too young to make that determination summarily sent back over the border. There is case law that suggests administrative ease alone is insufficient to satisfy a rational basis for this distinction. Of course, you know, any statute has to have at least a rational basis. And it seems to me this it may be very helpful to get 15,000 kids a year back across the border quickly, but it does not satisfy our procedural due process requirements. So of course, the remedy, in my view, would be simply treat all minors alike. If they're crossing that southern border, give them the protections that I have already discussed with you. And that's the procedural due process framework. I think the procedural due process framework is the easiest of the arguments to make. It flows out of a substantive due process right to a screening with respect to persecution and screening with respect to trafficking. So I tie it to a right that has been recognized in prior case law as a fundamental right. Supreme Court has not addressed that question. Is the right to an asylum hearing a fundamental right? We have a little bit of a circuit split brewing, so they may, but at least I have a right that I can attach to. For the equal protection question, it's clear. We have a facially discriminatory statute based on national origin. It says contiguous countries, but what's it doing? It's discriminating based on national origin. So the Fifth Amendment argument is a little trickier. We know the 14th Amendment has an express equal protection clause. The Fifth Amendment does not. But the Supreme Court has taken care of that for us, and it has told us that the equal protection is part of the Fifth Amendment due process, substantive due process bundle of rights. The next problem is, even though we have discrimination based on national origin, all we can get from the court is rational basis scrutiny. We cannot get heightened scrutiny because the individuals, due to the entry fiction, are not entitled to all of the protections of persons that we enjoy. They are entitled to less protection. So I'm struggling, I'm reading a lot of cases, I'm trying to begin to craft an argument, A, that it's irrational, right? That's one that's left for me. And B, that maybe there is something going on here where Congress's role should not be at its broadest with respect to enacting legislation that is facially discriminatory. One case that helps is a Supreme Court case called Jean v. Nelson. This was an equal protection case brought by Haitians. They sued on the grounds that the INS policy, which detained all of the Haitians instead of preferring parole as it paroled individuals from all other countries who were here and seeking a hearing, violated their constitutional rights. District Court agreed. The 11th Circuit reversed and said that there was no equal protection violation. And by the time it got to the Supreme Court, the INS had promulgated facially neutral rules, so it wasn't treating Haitians any differently than people from all over. So the equal protection problem had been resolved. The case was deemed moot. But there was good language in this case, which I really am basing my equal protection argument on. And the court said that that the INS has adopted nationality-based criteria in a number of regulations. So we know the INS does it, we know Congress does it. But these types of criteria are noticeably absent from parole regulations. What does that mean? Regulations where we make a distinction as to who can be detained and who can be released pending their hearing to determine whether they will be permitted to stay in the United States. This is consistent with the position that everybody in the litigation had taken, including the state, the government, the federal government. INS parole decisions should be neutral as to race or national origin. So I want to make the analogy that this is not a decision about who can come into the country. This is a decision about the procedural rights afforded to all people stopped at the border. And just as decisions regarding parole must be facially neutral, so must the decisions regarding asylum screening and trafficking screening. We cannot have distinctions based on national origin. We have a couple other examples in addition to the Haitians who were discriminated against because we had such a surge of them arriving in Miami, which some of you may be too young to remember, but it was in the news. It was a very sad situation in their country following political tumult and overthrow of the government, and people on boats that were not safe were leaving Haiti trying to make it to the United States. Many were picked up at sea because their boats were sinking. Cuba, we have a facially discriminatory law dealing with Cubans who arrived during the Mariel Cuban boat lift. This was enacted because there was a concern that Castro, along with individuals who were truly seeking asylum in the United States, Castro was opening the doors of his prisons and sending violent criminals over to the United States. Congress enacted a law that was facially discriminatory based on national origin. So that discriminatory law in our immigration law was upheld, even though regulations for aliens didn't have such sponsorship. Congress had a rational basis to discriminate against the Cubans who arrived during this period in 1980. So So the standard, it has to be reasonable, not arbitrary. The government must be relying upon some ground or difference, having a fair and substantial relation to the object of the legislation. That's the standard. So I want to distinguish the Castro legislation. We don't have dangerous criminals arriving. We have minors without parents and without documentation. And we have children fleeing poverty, abuse, violence, children who truly may be in need of our protection as refugees or to protect them from trafficking. So I would distinguish the cases that have upheld this on two bases. One basis being that this is not an entry decision, it is a procedural rights question. And two, that the discrimination is not rational, it's irrational. We don't see any good reason to provide fewer rights to children based on their national origin. So finally, on the equal protection side of this, I think there's a strong argument that Congress's power should be at its apex when it's dealing with national security. Their legislation perhaps should get some type of intermediate review when we're dealing with sovereign control of the borders. But when we're dealing with questions of procedure prior to removal, that Congress really isn't due any deference. And when they do begin to use national origin or race or other types of distinctions, which really identify a group of people quickly but don't have much to do with underlying assumptions regarding the individual who is being discriminated against, perhaps we should have a stronger standard of review, and that strict scrutiny does an excellent job of reeling in the legislature. And we have seen in times of national crisis, discriminatory laws have passed strict scrutiny. And what comes to mind, of course, is the Japanese internment law. And even in retrospect, we wonder if the Supreme Court made a mistake in that ruling. So my concerns are many, but I take the position that Section 235 is facially discriminatory. It is factually distinguishable from cases that have upheld discriminatory statutes in the past, and that the Constitution demands equal treatment as to asylum and other protections without regard to the immigration standing or status of the person asserting that right. There are many proposals to amend TIPFRA right now. Many are to reduce the rights of unaccompanied, undocumented minors, treat all of them as we are treating the Mexican children, and deport them expeditiously back to the Northern Triangle countries and Mexico, rather than affording them the provisions and safety that Congress has set forth in 235B. So my conclusion is that we do have a humanitarian crisis on our hands. These are children who do not have adults to look out for them or protect them, and that the country, by taking them into custody, has in fact taken on a parents patriae, a protective custodial obligation. And that in doing that, we need to then be certain that we afford to them the rights that Congress requires, that are required also under the international conventions that we are parties to. And I thank you for listening, and I'm happy to answer any questions, comments, or suggestions that you may have. Yes?
Have you thought about looking at other international law sources to bolster your argument, both protection of the rights of persons with disabilities, because a lot of our kids crossing probably are.
That's excellent. I hadn't thought of disabilities.
The children we haven't enacted,
yes.
But we can always.
Yeah, we have so many there's such great conventions out there that we haven't signed on to, particularly the rights of the child, the international convention. So that's so frustrating to me, but certainly it does reinforce sort of an obligation which is international to care for children. Any other questions or thoughts? Yes.
Yes, Professor.
Hi, Peter.
Lachlan, I heard you mention that you said this was a humanitarian crisis, and you made a good argument for it. Do you think that negates and cancels the homeland security issues, or are you addressing the fact that some people feel like there may be other reasons for the children coming here?
Yeah, I think that is one of the big issues, and that if we had a better screening process in place, we might be able to get a handle on that. What percentage of these kids will be entitled to some type of relief and be allowed to stay in the United States? When we look at the process on the Department of Health and Human Services side, it's a pretty large percentage who actually do obtain relief. They may not obtain citizenship, but they obtain relief, and that is and stay here for some period of time. And that the percentage that I have in mind is somewhere between 35 and 40% of those children. So that's a hard question to answer. We don't know. Yes.
Has there been any United Nations intervention in these crises?
Well, the United Nations has been writing several reports which are very critical of the handling of the crisis at the border. And I have looked at the arm of the United Nations that operates in the United States, and they have written, I think, 2012 or 2013, their report and recommendations, and it is, it is a very damning report. But to that end, that is where it stands.
Well, don't they have some kind of obligation internationally to intervene with financial resources and other resources?
Well, to my understanding, right now, the power of the United Nations is in terms of obtaining the support and then monitoring compliance with treaty obligations. And I'm not sure to the extent that they have an enforcement arm that can bring money and power to bear at the border. But I would be very interested and will now look to see what that authority is. Thank you.
All right.
Thank you.
Thank you so
Thank
much.
you very much.
Thank you, Professor. We now have Randy Waldman and Sarah Vinson, who are going to be dealing with an issue that's dear to my heart, addressing the mental health needs of youth in the justice system, a collaborative approach. I hope to learn a lot.
We are actually 10 minutes ahead of schedule, which means we can talk longer. We'll see how that goes. So I'm Randy Waldman.
I'm Sarah Vinson.
And our goal today is to talk about a project that came about at Emory University. I'm the director of our Juvenile Defender Clinic. Sarah, at the time, was a adolescent and child forensic psychiatry fellow. I'm trying to put all the words in there. And we had just started a collaboration between those two projects where the program would rotate, the psychiatrist would rotate through the Juvenile Defender Program. We're going to talk more about that, how it works, and what some of the examples and some case studies throughout the process. To start off, though, we just want to give you a little bit of background about mental health issues in the juvenile justice system to see why this program was so necessary.
So in the general population, mental health, can you guys hear me? Am I close enough to the mic? In the general population, mental health issues are pretty common in children and adolescents. So 13% of youth aged 8 to 15 and 21% of youth aged 13 to 18 have a mental illness that is significant enough to cause impairment in their day-to-day lives. If you look at delays in treatment, they are significant. You're looking at 8 to 10 years, but then a lot of those kids never get treatment at all. The number is looking at 80% that never receive specialized mental health services of any kind. Now, if you're symptomatic, if you're depressed, if you're irritable, if you're anxious, there are all sorts of opportunities in that 8 to 10 year time period for you to get in trouble and do things that land you in contact with the juvenile justice system. And what we know is that in the communities that have the least access to mental health care, you also have the highest number of contacts with people who can arrest you, the highest proportion of schools that are part of this school to prison pipeline and have a lot of contact with school resource officers and that sort of thing. So those delays in treatment are really significant. Since we're in Florida, I thought I would just show you where our state stands. I'm actually a native Floridian. Per capita mental health spending, 48. How you're 48 in per capita mental health spending and still get a C-, I'm not sure. But they managed to. But you all know the infrastructure for mental health services in Florida is very, very poor.
So this slide, I'll credit it to Sarah, and then I said, what do you want me to talk about? So the beds are actually, the one on top is a hospital treatment facility bed. The one on bottom is a juvenile justice bed. I give that as clarity because I did not immediately identify that myself, and you guys are sitting much further away. So where do we go from here? What are we talking about? A child has two routes to receive mental health services. One's significantly better than the other. Contraction of mental health services, Sarah and I were talking about this, it seems as though it's a new thing, except that apparently we've been writing about contraction of mental health services in the community since the 1800s. So continued contraction of mental health services available in the community are oftentimes, and there are many theories that say that kids are ending up in the juvenile justice system because that's where you get treatment. I represent some kids who go to what we call our psychoeducational centers, the schools that are for our most severe emotional and behavior disturbed students, right? That's what their classification is, that's why we send them there, that's why they're receiving the education services in the place they're receiving them. I've been in rooms where they've sent kids to our Department of Juvenile Justice, knowing that those kids are incompetent to proceed, saying, but we're making the referral anyway because we think they will get services that way. You are the services, people, right? But think about a kid who's not quite in our psychoeducational center, who's in our regular community school and acting out. And a school system thinks, well, this really isn't that bad, but I know the kid can use some help. Again, option number one is you make a referral to a mental health service provider, but there aren't that many of them. Wait lists for them can be 8 to 10 months long, if you get one at all. Many of them, Sarah notwithstanding, are not that good, so they provide medication every 30 days, maybe, right, with a 5-minute visit for those 30-day medication appointments. And so the schools aren't seeing improvement. The communities aren't seeing improvement because there's no real mental health services. They say, you know what? You know where the kid can find some mental health services? In our detention centers. And so we're using our detention centers. This is true in the adult system as well. We're using our jails, but we're using our detention centers, we're using our jails as mental health providers because they're guaranteed to get something while they're locked up, and they're not guaranteed to get anything while they're out in the community. With that, right, with that as a background and why we're here, 70% of the kids in the juvenile justice system have a mental health disorder, and approximately 20% have a serious mental illness, right? Our juvenile beds, our detention centers, our facilities, the kids I represent every day, the kids you all represent or will someday represent every day, are all in our system because of mental health issues. Right? That's who we're seeing, and they're there because we don't know what else to do with them.
So whenever I talk about kids and things that get them into trouble and mental health issues in them, I always use this slide because I get asked this question, is it biological, is it their environment? And you know, that whole nature versus nurture thing in our field, we've come to realize it really is a false dichotomy. Say for instance, you have a kid with a biological predisposition to bipolar because their mother has it. Well, even if your biology turns out okay because you get some good genes from dad, you're being raised by a parent who may not be consistent, who may make impulsive decisions, who may or may not have access to treatment herself. So there's this interplay between kind of the biological vulnerabilities and the social ones. Or if you have a kid who maybe naturally have a more irritable temperament, this is a child who's more likely to aggravate their parents, to alienate their teachers. And so this is a kid who may be more likely to be abused or singled out or kind of labeled a problem child, and then have these negative interactions with adults that feed into their sense of self and into how they interact with the world. So there is this bi-directional relationship between environment, which we know is a big issue in a lot of these kids' lives, and the biology that they may have come into the world with.
So there are a number of ways that kids that we see present themselves and end up into the system, right? Some of them are the kids that Sarah talked about where biology is at play, right? These are kids who are predisposed to having a mental illness. These are kids who have been diagnosed with a mental illness long before they ever have involvement with the juvenile justice system, right? Their juvenile justice system involvement oftentimes comes as a result of that pre-existing mental illness. A second category of kids is kids who have what we call antisocial behavior, right? The kids who are acting out in school, the kids who are getting in trouble in school, the kids who are just kind of a pain in the ass over and over and over again. I want to be recorded. I should stop.
It's okay. It's okay. All adults here.
Right? So these are the kids who end up getting, we know it, diagnosed with oppositional defiant disorder. Right? They are in fact diagnosed with a mental health illness because of their delinquency behavior. Right? Their delinquency behavior might not be causing their mental health issue, but right, it comes after their delinquency behavior. And then we call this third category of kids, right, who are probably going to do just fine and who are on their merry way and things were going great for them. And then they experience a great trauma in their life, whether that be abuse and neglect through our child welfare system, whether that be significant trauma, either witnessing or involved in drive-by shootings in their neighborhoods, a trauma that comes from living in an extraordinarily dangerous neighborhood, whether it be victimization of violent crime. Given one of our case examples, whether it's a rape that is, thrust upon them at a young age. Those kids who experience severe trauma and then start acting out as a result of the trauma that comes into their lives. Can't read that. We'll skip that one.
So there's a well-cited article that looks at psychiatric disorders among youth in juvenile detention. And I want to talk about this with a caveat that this is largely done by self-report. And when it comes to asking a kid with ADHD, do you have ADHD, they're often not the best at telling you that. So these ADHD numbers are probably an under-reporting. That said, at this point, we've been working together 3 years. Almost every kid who Randy has been labeled with ADHD because it's kind of the easy diagnosis to make. You get a parent to do a checklist, you get a teacher to do a checklist, voila, ADHD, and pediatricians are comfortable with prescribing medicines for it and diagnosing it. But a lot of those kids, it's not ADHD. It's their externalizing depression, it's PTSD, it's trauma. So a lot of those kids are going to come to you with that. But I still think it's probably higher than 21% though. But this actually looked at kids who were detained, and as you see, the girls do have a higher rate of psychiatric disorders. We see that in the adult population as well. When this was done, PTSD was included with those anxiety disorders. So that probably accounts for some of that difference between boys and girls. But as you can see, substance abuse is big, and under disruptive behavior disorders, conduct disorder, and oppositional defiant disorder, which of course you would expect to see a lot of in these kids. Another caveat with that, though, is that if you make the diagnosis correctly for those two, if something else accounts for that child's behavior that allows you to check off that list, you shouldn't make that diagnosis, but I see it done all the time. So a lot of these kids will come in with those diagnoses, but if there's something else that better accounts for it, like trauma, you're not supposed to do it. So this is an angry kid in the middle. And the point of this slide is to illustrate that there are a number of reasons that a kid may be irritable and angry and aggressive, other than oppositional defiant disorder and conduct disorder. ADHD has an irritability component to it. Trauma can make children more reactive and if they feel as if they don't have time to think about what they should do, and it's life or death because they've been in life or death positions before, they may be more likely to act out aggressively. Substance use, social capital, particularly when you have a kid from a tough neighborhood. And I had one young man outright tell me, when I don't take my medicine, people know not to mess with me, right? So if you're in an environment where you have little room for error and the weak do not survive, it may be in your best interest to be a little angry and have a reputation for that. Depression for children, there's actually different diagnostic criteria for children versus adults. This is another issue with having people who don't know kids do these evaluations of them. So with kids, you don't even need to have a persistently sad or depressed mood to make a diagnosis of depression. As long as you have irritability, you can make it in kids because it presents differently in them. So sometimes that anger, that aggression is because of depression, and then bipolar disorder as well. So the history of abuse in detained youth, I just wanted to quickly touch on this because it is such a significant issue, and even these numbers are likely underreported, but particularly when you look at females, 35% have suffered severe physical abuse, 76% moderate physical abuse, 41% any sort of sexual abuse. These are tremendous numbers when you're working with this population, when you're trying to evaluate this population. It may take you doing multiple visits or sitting for an hour or two before they really start talking to you. I've worked with child fellows who sometimes come into the interview, and if the child doesn't respond to them initially, they think, oh, they're being disrespectful, they're being uncooperative. But they come into it with this idea that kids should respect adults. Where if a kid has lived in a world where adults have done really mean, awful things to them and lied to them, you don't get respect just for being an adult. And so it takes time to sit with that kid and understand them. And this is a lot of the kids that we're dealing with in the juvenile justice system. And then for boys, 15% severe physical abuse, 68% moderate, 11% of sexual abuse. So these are really big numbers, and like I said, even these are likely an underreport. And this is up here just to illustrate the number of ways that trauma can manifest in children. It can affect the way they think, the way they feel, the way they see the world, the way they see themselves. There is no aspect of who a person is, how they think, how they experience the world, that cannot be affected by trauma. Not to say that this happens in every child who experiences a trauma, but these are all the different ways that it can come into play. So if you're trying to evaluate a child, and they don't want to talk to you, or they want to avoid discussing it because that can be one of the symptoms of PTSD, that you want to avoid anything that reminds you of it. Or if you have a kid who's on the 5th caseworker and the mom's phone doesn't work and you can't reach the auntie either, it may be hard to get the history of what this kid has experienced and gone through. And so it's really easy to miss those histories and how they may be impacting the child sitting in front of you. So as a child and adolescent psychiatrist, if you don't do an extra year of forensic training, the only thing that you're required to have is an experience in legal issues, which may be as little as a couple of lectures. So just understand that when you're consulting to people, if they don't have forensic training or forensic experience, there may be very little that they know about interacting with the system. And it's a problem because a lot of the kids that we serve, the reality is they're interacting with you guys and with the juvenile justice system, whether we understand it or communicate with it or not.
So then you get lawyers and how much they actually know about mental health issues. How many of the law students in the back row have taken a class where mental health issues have been addressed? Yeah. So Sarah wrote words on her slide, and I was like, well, let's put some books up. Because what do we know when we go to law school? We read some law. We read some statutes. Maybe we can find a condensed version of the DSM-5 somewhere, if we're lucky, right? We don't learn anything about this when we go to law school. For those lucky students in the room who have not yet graduated and still have time to find a clinical experience or an externship experience, do it, because that's where you'll find some clients. But even most students graduate law school without even talking to a client, right? They've never met one, they don't know who they are. We're not that good, right? We think when we go to law school that we should transition from law school to practicing because we're smart enough to do it, and we'll figure the rest out later. That's not really kind of the way it works, right? There's a lot of stuff that we show up and you start working with the kids and you start trying to figure out what's going on. And quite honestly, I get a report from somebody, and what do I know? I've got to think it's right? So I get these reports, and all it says is that my kid has conduct disorder and ADD. And I'm like, great, my kid has conduct disorder and ADD. My judge is going to love that. But who am I to say that's not really what it is? So, a decade into it, I'm like, that ain't what it is. I know it's not what it is. I just need to find somebody who's willing to tell me that's not what it is. And so you start working because you start reading kids and you start understanding things, and you're like, but I know there's so much more to my kid than that. Can I get somebody to spend more time and realize there's so much more to my kid than that? But we don't have training in that, and we don't understand that, and we leave law school without all of that. Which is where we get to merging our two programs, to get to a place where we can actually, in the law school environment and in the med school environment, get to a point where we each understand what it is that we're doing. The idea being that my law students will get a report and will have a psychiatrist they can immediately go to, or a psychiatric fellow they can immediately go to and say, can you take a look at this? And does it seem right? Should we do some more testing? Should we understand something else about this child? Where we have our law students talking to the psychiatry fellows, where they can sit in a room together and understand more about what it is that goes into the makeup of our child, where we understand more about what we can propose to a judge, right? Because what it all comes down to at the end is, what are the treatment possibilities? Well, with ODD or conduct disorder, the answer is not much, because they're pre-sociopathic, is from what they tell us, right? That's what we know, right? You go as a juvenile defender and you show up and they say, conduct disorder is the precursor to sociopathic behaviors. Your child's done, let's lock him up. Well, that's not the answer we're looking for. But it's also probably not what's going on with our clients, because we know that ODD and conduct disorder are being diagnosed way more often than they're actually occurring. And so we're trying to expose the law students at this early stage to dig deeper, to not trust the reports that come to you, to ask tougher questions, but to have an actual basis from somebody who's in the field to learn some of the underlying causes and issues, and some of the underlying, or some of the overarching treatment recommendations and recommendations that we can make to a court. Psychiatry benefits.
Yeah, so this is a big part of our patients' lives. And that's part of why I chose psychiatry out of all of the different fields of medicine, because we are supposed to look at the person holistically from a biopsychosocial perspective. This is a big part of their social experience. So I think it's important, even if you are a general psychiatry fellow and not a forensic specialist, to understand this, particularly if you're going to do public sector mental health child work, because so many of your children are going to have contact with this system. So for us, I mean, we don't do cross-disciplinary training often, even with psychologists and psychiatrists, let alone in an entirely different field. So this really was a big gap in our knowledge and our understanding, which this program has allowed us to fill in some way.
So who we are and what we do, I run our Juvenile Defender Clinic. It is a program for third-year law students who get sworn in to practice law under my license. They represent kids who are charged with delinquency and status offenses in our juvenile court system. As a general rule, although you see in our case examples, most of our clients remain in the juvenile court system. They are not tried in our adult system. Some of my juvenile clients I grow fond of and attached to, and they graduate, and I stick with sometimes. And so you'll see some of our charged as adult kids coming here as well. But as a general idea, our program sticks with kids in the juvenile court system. I generally supervise about 8 law students per semester. They have the option of remaining for a year, but I usually take about 6 new students in the spring semester after the fall semester. And like I said, most of them, probably all of them, come to me with a diagnosis of ADHD. If not all, at least 75% of them come to me with that diagnosis. But a large number come to me with special education needs, high rates of, a large number diagnosed with bipolar disorder for a while, just a mental health diagnosis of some sort as they come to me.
And with Emory Child Psychiatry, as Randy mentioned, when I first started with her, I was a forensic fellow, so I was in training for forensic psychiatry. And since then, I've joined the volunteer faculty at Emory, so I supervise the child-trained forensic fellows at Emory and the child psychiatry fellows at Emory, who now rotate through the Barton Clinic.
So our goal now is to talk about 3 of the different types of cases that we've worked on. Well, 3 different specific cases that really represent the types of work we've been doing as a collaboration. We're going to start with Brenda. Brenda came to me just shy of her 16th birthday. She was charged with battery. It seemed like every other case that I get from the juvenile court. I have a female just shy of her 16th birthday. She has very little, I think she had no juvenile court history prior to this, but if you looked at her school disciplinary record, it was about 12 or 13 pages long. She had a history of fighting in school. She had a very long history of school failure, school absenteeism, school fights. She was, it seemed to us that there was something else going on. This was another school fight. She got into a girl fight. But when we talked to her, you learn that she had such a short trigger. Everything set her off, no matter what it was. And she said, I don't know why. I felt the need to fight all the time. And so our idea was, well, there's got to be something else going on with her. We also had an inkling. So we knew that she'd had some trauma in her past. We weren't quite sure what it was when we first started. But she came to us, and by the way, at school, despite her 12, 13, 14-page disciplinary history and no school success at all, she was not being serviced as a student with a disability in any of the categories. So she came to us, she talks to us, she's living with her aunt when we meet her. Well, she's living with her grandmother when we meet her. And I'm trying to find out why. And digging is harder and harder and harder. And it turns out that she'd been abandoned by her mom, she was with an aunt, then she went back to her mom, and then she went to her grandmother, and we find a DFACS, right? She's with her grandmother under no real documentation, but a DFACS safety plan, which means DFACS did nothing but said, let's resolve this by putting you somewhere else, and then we're not going to actually do anything. So she's living with her grandma at the time, but we're not sure what the safety plan is about. Nobody's really willing to tell us. And then finally she say, well, I was raped. And it turns out that she was raped when her mom, who'd abandoned her for most of her life, came back and got her at the age of 12. And she came back, left her with a boyfriend, and the boyfriend raped her. She ended up getting pregnant as a result of this rape, and she aborted the baby. This is about 3.5 years before we meet her. And we asked her if she'd ever received any treatment for it, and she had some church therapy. We ultimately got a letter from the church detailing her church therapy, which I'll let Sarah maybe talk about it. It was a little, it wasn't so much therapy, if you must know. So at this point, we decided, right, we really need to try and go a different route with the court system, but I also needed to get her services in school, and I needed to happen immediately because her suspensions were piling up, and I was trying to make sure she wasn't expelled, which we do with no alternative placement in Georgia quite regularly. And so our goal was, I need to get her diagnosed, I need to do it quickly, I need to figure out how to deal with her court system stuff, and I need to figure out how to do something with school. So Sarah was sitting in our office, and I said, Sarah, I got your first client. And so this was the first case we worked on together.
So I went to see Brenda. I have to make sure I don't call her her real name.
We have changed names.
Yes,
Right.
we have changed names. It may slip. I went to see her at her grandmother's house. Her aunt was actually there that day. When we sat at a table, when we talked for probably about 2.5 hours. A couple of the law students were with me. They weren't in a position where they could tell her what to say or anything like that. But I also spoke with her aunt, reviewed her school records, and eventually went to an IEP meeting at the school. And what I found out from both her and her aunt is that she had never really had a close relationship with her mother. Her mom was very young when she had her, and when her mom kind of went off to Job Corps and left her with her aunt, she became much more attached to the aunt and never really wanted to leave the aunt's custody. It was still unclear why the mom took her when she did at 12 years old. At the time that her mother took her, she severed her ties with her aunt, who'd been her primary caretaker and was her primary attachment figure, with her grandmother, and also with the counselor. So she had seen a counselor because of some of the behavioral issues at school. And according to the counselor's letter, toward the end, she was starting to open up, but her mother also abruptly severed that relationship as well. So she was with this woman that she wasn't particularly attached to. She was cut off from the family that she knew, and then she was raped. Both she and the aunt were interviewed separately, gave me very consistent stories about what happened, where the abortion was, the whole nine. So I thought that her story was very believable, and I had no doubt about the credibility of it. And even though the family knew this had happened, no one had went to get mental health services for this child, and I will say that that is not uncommon. A lot of times people don't want to talk about it, they don't want to acknowledge that it occurred, they want to sweep it under the rug, it makes them uncomfortable, so they just tell the kid to kind of deal with it. And she had never gotten any help. In the letter from the pastoral counselor, she did say, to her credit, this child needs to be seen by a mental health professional in her letter, but that never happened. As Randy mentioned, she had a long history of behavioral issues in school, had never been psychoeducationally evaluated there either. She did have an aunt who had a prior diagnosis of bipolar. Some had questioned whether Brenda, the client, had a diagnosis of ADHD because of her school behavior. Aunt said, I don't see that at my house. Aunt's house was warm, structured environment. Mom's house, that wasn't the same way. She did report those symptoms, but not seen by the aunt at all. And Brenda was able to say, she was very insightful, particularly for somebody who hadn't had a lot of contact with therapists, that she felt angry, that she felt like her temper was shorter than it needed to be. She described feeling scared. She described having difficulty trusting other people or letting other people close. She did say that she had a small group of friends she trusted, that she interacted with well, and her whole kind of countenance changed the way teenagers do when they talk about their friends. But she did talk about that difficulty with letting other people in, or with assuming that people weren't trying to hurt her or take advantage of her. And she told me about the molestation and the rape. In the report, I just said that she and the aunt gave consistent histories and that there was physical evidence of what occurred to her. I didn't go into the fact that she got pregnant and had a rape. I just kind of summarized it that way to protect her privacy as much as I could. She was someone who showed a lot of emotional reactivity, like appropriate emotional reactivity during the interview, and that's something that we look for, particularly when a kid has gotten into a lot of fights and they have this conduct disorder diagnosis and they're pre-antisocial, which is, it's a whole other talk, but there's a lot wrong with that. But I make it a point to look for and document the fact that this child does relate to people warmly, that she does have the capacity for feeling different emotions, for remorse, for guilt, for shame, for all those things. And at the end of my interview with her, I didn't think she had ADHD. I thought that she had PTSD, and that accounted for a lot of the trouble that she was getting into. That few seconds that a lot of kids have to say, how am I going to react to this? She didn't have the luxury of having because of the trauma and the instability that she had experienced in her life. And she had never really been taught how to deal with those really strong negative feelings.
So after we got Sarah's report, we took that 2 different places virtually immediately. So one of the luxuries of having your own psychiatrist on call is that you get a report in 2 to 3 weeks instead of in 2 to 3 months, right? So we did all of this before our adjudicatory hearing was scheduled within the courts. And we used the report, immediately sent it to the school district and said, please treat as a child with a disability. We want services to start immediately. That started in the school system a Section 504 plan. Sarah came to that initial meeting with us. She was able to explain for us and for the school system why it was a disability, why it was interfering with her learning, and why she would be qualified under 504, and helped us design the 504 accommodations that she needed. And that happened, I'd say within a week of having the report. We had an IEP meeting. I had, at the time, a very good relationship with the school district lawyers. They fired their lawyers, and that meeting probably would still be waiting right now with their new lawyers, but at the time we were moving quickly when I'd asked for something. So she immediately started receiving services in school. At the same time, we sent a letter to, at our adjudicatory hearing in juvenile court, we showed up and we asked the court system, which had just gotten grant funding for what was called the Journey program, which is a mental health court diversion program for girls. And we referred her to the Journey program. Again, Sarah got involved with multiple conversations with them because although it is a Journey program, although it is a mental health program, I'm not sure they all understand mental health diagnoses. And there were a lot of questions about, well, does she really need mental health service? Like, it was a little bit challenging. It was in the early years of the program. There was a lot of convincing, I think, in phone calls back and forth with Sarah about, do we really need her to be in mental health court when she's not ADHD, but she has PTSD, kind of thing. So she did go into the Journey program. We can talk about whether that's a good thing or a bad thing. She probably would have got 6 months probation for her offense. She ended up spending 2 years there. But she did, right? It does clear your record. It is a diversion program. She did probably pick up 4 more offenses that all got wrapped into that while she was in the Journey program. And so, in the end, probably yes, a good thing. Mental health courts, therapeutic courts. Again, a discussion for a different day on whether they're overall helpful or not. But for her, it did prove to be successful because it was a place where she could receive mental health treatment for the first time in her life, where somebody could stay on top of her. We moved her as a mental health court team. They actually placed her away from the grandmother and back with the aunt. The aunt was very willing to remain involved. She was a stable environment. The mom had recently, and so one of the reasons we figured out was triggering her and why suddenly she was getting arrested so regularly is that the mom had just recently moved in to live with the grandparents. And that shortened her fuse even more so. And things were not going well there, and mom was trying to insert some discipline on her, but had never parented her, and she was mad at mom. And so as a mental health court decision, they placed her with her aunt again. There were some hiccups along the way. I mentioned several other arrests, right? She wasn't immediately cured. There were some hiccups along the way. Mom actually took custody again for a little bit and brought her to a different county, and so she was out of the program for a little while. She came back to the aunt's house one more time. And so again, our clients' families' lives don't suddenly become perfect just because you find some therapeutic interventions for them. But her rate of right, the last IEP meeting I had for her, she is still in school. She is doing significantly better. She is on track to graduate high school. Not quite on time because she's 18 and a half at this point, but she is on track and is dedicated and committed to graduating high school. The last meeting, they say we've seen her grow up. We've seen her be able to say, that's bothering me right now, I need a break, instead of punching. We've seen her be able to actually advocate for herself and identify what her triggers are and respond to those triggers in an appropriate way instead of an inappropriate way. So she still has a way to go. The most recent news is, unfortunately, she is pregnant. So we were excited she made it to 18. We wish it had lasted a little longer than that. But she is, I think in a better place now than she ever would have been. I think, she has not had, not quite as bad as North Carolina, but our adult age of jurisdiction is 17. She's 18 and a half now, has not had a single offense as an adult, which I think for her and given what was going on with her is fairly remarkable. And so we're hopeful that she is on a really good, committed path. And she's also been offered a part-time job. She has having some health issues and is trying to work around those. But I think she's on a fairly successful path at this point. Anthony, I call him Tony, because that's easier for me to say and less likely for me to mess up with his real name. So Tony is one of those kids, if you recall, I say sometimes you get attached to a child and keep him. Tony is a kid who came to me as a real youngin'. I think he was 12 and a half or 13 when he came to me, with a stupid offense that I continue to believe was not a crime. But nonetheless, got involved in our juvenile justice system. His family is fairly involved in the juvenile justice system, right? It is not solo to him. He came to me as a pre-K reader, but has average intelligence. He had been in special ed since kindergarten. I started working with him fairly extensively in our juvenile court system. In our school system, he received compensatory services. He received a whole lot of tutoring. He was doing great. He had a couple of hiccups with the law, but nothing major at all. He was really trying to stay clean. I had been working with him for 4 years. He was doing great. And then one day I get a call. And for a lot of my kids, when I get the call that says they're in the adult system now, I'm like, yeah, kind of saw that coming. This one, I did not see coming, and it was heartbreaking. And he was 16, and he got picked up for an armed robbery. So we have exclusive jurisdiction in our Superior Court for our 7 deadly sins, one of which is armed robbery with a firearm. I continue to believe his involvement was minimal. Tony's involvement with his offenses is always minimal. He is not the criminal mastermind. He is always with a child who is the criminal mastermind. But he's kind of like I'm going to go along because it's all good. And he's charged with an armed robbery with a firearm. His co-defendant has 5 offenses. He's implicated in just one of them. I still don't think he did anything. He was in the car, he says, going to Krispy Kreme. When the other kid gets out of the car, robs somebody, gets back in the car, and takes the police on a high-speed chase. I know that sounds unbelievable, but I do actually believe him. I do, because I know him so very well, and it sounds so very much like the kind of thing that happens to Tony, right? Everybody agrees, right? Nobody can identify him. Everybody agrees that it's the co-defendant who got out and did the armed robbery. Everybody agrees that it was the co-defendant who did the driving, right? Everybody agrees to all of those things, but nonetheless, he's in Superior Court. He's charged as an adult, and he makes a statement. It's not the most incriminating statement in the world. It really isn't, right? But he puts himself in the car going to Krispy Kreme when the robbery happens. And the only other way they can actually put him in the car is with his co-defendant statement, and his co-defendant's never talking, right? His co-defendant ain't going to trial and ain't testifying against him. We're sure of that. So we're trying to get rid of him putting himself in the car at the time of this armed robbery. Because that's what they got against him. We tried forever to get them to send the case back down to juvenile court, which is purely a prosecutorial decision. We do not have a reverse waiver for armed robbery with a firearm, so it's purely within the prosecutor's hands. And the prosecutor says, absolutely not, because they're going to keep the co-defendant in Superior Court, and they don't like splitting cases up. And so there is nothing we can do to get Tony back to juvenile court. So now we're trying the case. We're working on trying the case. We're thinking about trying the case. And I called Sarah in to see what we could do about suppressing his statement as not being knowingly or voluntarily made.
So as part of his evaluation, I listened to what was available in the audio recording of his statement. He said that it didn't record everything that took place in that room, but we listened to what we had.
One of the key things it didn't include was the actual reading of Miranda. So, I mean, he says it didn't happen, and it ain't on the recording, so it really might not have happened. But there's a form that he signed.
Right.
Remember, he can't really read. But there's a form that he signed.
Right. He reads on a 3rd grade level, and that's all in it.
It's better than pre-K.
Better than pre-K. So we reviewed that. We reviewed prior IEPs, a former psychological evaluation, talked to his mom, and then we actually saw, I saw him with the forensic fellow once, and then the forensic fellow went back and saw him again. His background was more stable than a lot of the kids we see, actually. Had been with his mother his entire life, had a supportive grandmother. Father was incarcerated early on in his childhood, but since he'd been out, father had been involved. And the issues at school that he had, the behavioral issues, were more around him trying to avoid work. He wasn't one of those like aggressive, disrespectful, antagonistic children. It was really, in his words, I didn't really try because I wasn't good at it about school. So it was more about him trying to get out of trying to do things that he felt as if he couldn't do and just didn't enjoy doing because it was so hard for him. But he didn't really have significant behavioral health issues. He did not have any history of abuse. He had a prior diagnosis of ADHD, which I thought was a legit one, and he showed some evidence of that during the interview because, as you can imagine, in jail they're not prescribing people stimulants for their ADHD. So I did think that was a legitimate diagnosis for him. And his mom said, a lot of the things that Randy said, that he really got in trouble when he was with other people, that he wasn't a ringleader or mastermind or anything like that. He was a really likable, really respectful kid, and this is what had been reflected in the other evaluations as well. And so we talked to him about what happened the day that he was picked up by the police. First of all, they arrived at his mother's house, 3 or 4 patrol cars looking for him. And when they picked him up, they told him that he was being investigated on a murder. And they kept saying the word murder, and he didn't ask for a lawyer, he didn't ask for his parent to be there, he just knows that they're saying murder at him. There's some people who are in police uniforms and some people who aren't. He thinks very concretely, so if you're not in a police uniform, he's not really sure if you're a police officer, even though you're riding with them at the station with them and in the room with them. To give you an example of how he thinks, when we were asking him about a sort of oppositional behaviors, we asked him, do you talk back to your mother? To which he replied, yes, when she asked me questions. So it wasn't as if he was just trying to play like he didn't understand when it came to talking about his statement. He really had a hard time understanding things and thought about the world in a very concrete way. So he has these police officers, or he's not sure who they are, saying murder, murder, murder. He's like, no, I wasn't involved. I was just in a car and this is what happened, but I didn't murder anybody. And so he really wanted to make sure that he didn't go down for murder because that's what he heard. And that's what they kept repeating according to him. Now again, this isn't on the tape that we have. But
Murder's mentioned in the tape.
Murder's mentioned in the tape.
Yeah,
No.
for sure.
Yeah.
He's like, I don't want to talk about that murder thing. Tell me about the rest of this stuff. Is what the police eventually said.
Right. But the part where the police is like pounding on the table saying, tell us about the murder, that's not in the tape we have. So this was a kid who usually did what adults said. We know that children, even the ones who get in trouble, are still more likely to feel as if they have to answer questions an adult asks them, particularly if you're in a police station and they're yelling at you, calling you a murderer. Teenagers are not as good at weighing pros and cons when their emotions are high. You can imagine his emotions were quite high in that moment. This is a kid who has ADHD that's not being treated because he doesn't like taking his medicine. So the way he attends to things and processes things and retains things is impaired at baseline. And then you have an emotional, scary circumstance on top of that. And even though he signed this statement saying that he understood his Miranda rights, he reads at a third grade reading level, so he didn't understand it. Part of the evaluation was us asking him, key language, and we asked him what the word right meant. And he said, right can mean so many things, like people have a right hand or there's a right way to do things, but right as something that he didn't understand it at all. And of course that word was used multiple times in this statement he signed, saying that he understood what he was doing. So based on all of those things, our opinion was that he was not competent to waive his Miranda rights at the time of his interrogation.
I want to point out, again, kid I worked with for 4 years, I promise you I spent time with each of those kids talking about making statements. I promise you that Tony and I had at least 30 conversations about the fact that he should never talk to the police. I swear he knew that that was what he was not supposed to do. But, right, when I read the report, it actually finally clicked, because I had the conversation with him and I was like, seriously, dude, why'd you talk? And he's like, I don't know, they were throwing this murder thing out, and really there had been a murder nearby. And so the police were actually not making up the murder thing, they were actually trying to figure out if they can tie these kids to that murder too. Which they couldn't, and they found the guy who did the murder, and it had nothing to do with these kids, but it was nearby, so they were trying to put it all together. And when I read the report, and he talked about the distinction, because he had mentioned that his dad was there too when he was picked up, and he said, don't talk to the police, don't talk to the police, is that he was very clear in telling me that he did not talk to the police. He talked to the guys in plain clothes. And I had that aha moment, and I was like, damn you, Randy, you need to do a better job, right? Because it never even occurred to me that the police distinction, police detective, right? That never occurred to me, but that was actually very clear in his mind that Randy says I can't talk to police officers, but these guys were not police officers. And he did not, in his mind, make that distinction. We ultimately ended up reaching a plea deal in this case. Prior to the report, prior to where we were, the DA was very firm on, so armed robbery with a firearm in Georgia is, in addition to not being able to go back to juvenile court unless the prosecutor says so, is not parole eligible and is a mandatory minimum of 10 years. So we started negotiating, and the lowest we could get the DA down to was 14 served 8, so 14-year sentence with 8 of them to be served incarcerated, but as a robbery instead of an armed robbery, which makes it parole eligible and also makes it first offender eligible. We rejected that. My client rejected that. He's like, no, man, I just didn't, and I really don't, I think we had a triable case. I really don't think he did. His involvement was, he was there, sure, but I don't think he knew what was happening. And you can see in the video of the police chase, if you know it's him, because he points it out on the video, it's like him slapping the guy, saying stop, 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 and you can see his hand going, trying to get them to stop. I don't think this was part of his plan at all. Ultimately, we had this document, we filed our motions, I filed a few others for good measure. We rejected, we were announced ready for trial, and after that the DA came back to us and actually still wasn't going lower, and the judge said, I really don't want to try this case, let's hear the motions now. And the DA's like, I haven't read the motions, Your Honor. And the judge is like, well, that's your problem. I have some motions in my file, let's hear some motions now. Ultimately, the judge asked us to pre-try the case. We pre-tried the case. The DA was still not offering anything less than, I think, 6 at pre-trial, which we were still not taking. The judge just said, let's pre-try it and see where we go. And the judge said, I'm going to give him 6 serve 3. And to which my client said, so 6 years, 3 years is how much time he'll do. He'd already been in for over a year. And given the 10-year mandatory minimum, he finally said, I'll take it. Not our desired outcome. He is first offender eligible, which means that once he finishes the 6th of the 6 served 3, his record is wiped clean entirely. So he'll be out. I just saw him like 3-4 weeks ago. He's doing okay. He's still on a youth unit. He turns 18 next week. He turns 18 next week, so he'll move into Gen Pop next week. He's looking at 1 more year, and then he'll be out at 19, which is not an ideal world for anyone, but it's certainly a better world than him being out at 26 with a felony conviction on his record for the rest of his life. All right, and then they get progressively worse. Well, actually, better outcome for Dante, but progressively worse in the offense world. This was a case that did not originate with my office. It originated with the public defender's office. But having heard it, and I worked very closely with our local public defender's office, we decided that we would loan out our psychiatry fellow program to the public defender's office in the interest of this child. So Dante was 13 at the time that he was charged with sex-related offenses against his 4- and 8-year-old siblings. Again, bad facts. Bad facts are always bad. His background, again, because we live in Georgia, almost all of our sex offenses are automatic filed in our adult system. So he was tried as an adult. And he was facing mandatory minimums, non-parolable, all those good things that come along with our, what we call our SB 440 exclusive jurisdiction offenses. His background, he had lived with his mom until he was 8. There was a significant amount of abuse in the mom's home, domestic violence, drug use, instability, back and forth, not a lot of goodness going on in his life. He moves to live with his dad, where things are relatively stable. He does fairly well. His school grades are improving, right? His life is going well. At the age of 12, his dad gets sick and he can't care for him anymore. He briefly moves to an aunt's house, and then from the aunt's house moves back to his mom's house. Mom's house has not improved in the intervening 4 years. He is frequently left home to care for his younger siblings. And during it's during this, he's back at mom and he's asked to care for the younger siblings that the allegations of abuse have come to light. He lingered in the adult system for quite a while. He was indicted on the 2 sex offenses, one against each child. He was the good news in Georgia is that if you're under 17, we don't actually transfer you to the county jail. So he's in our youth detention center while pending all of this. He was in for over a year when I started talking to the public defender about this case, and we started trying to figure out what we can do. The DA had, after a year, agreed to transfer the case back down to juvenile court, which is great. They often do that. They're a little more likely to do that in sex offense cases and 13-year-olds than they are in the armed robbery cases, quite honestly. So he's coming back down, but they come back down with an agreement. So his agreement in juvenile court was that he'd be committed to DJJ, our Department of Juvenile Justice, for 5 years, 3 of which he would serve in restrictive custody. And that's an agreement, but the great thing about agreements is that our juvenile court judges don't have to live by them. The parties do. So the state has to stand up and say 5 serve 3, and the defense attorney stands up and says 5 serve 3, and then the judge can say whatever they want. The judge can say 5 serve 5, or the judge can say 5 serve none, right? You're done. Judge can do whatever they want once the case comes back to them. This judge, for some reason, because she's not that nice, decided that she was, this case, she grabbed onto and for some reason decided, I don't think this kid should serve time, but I need somebody to provide me with information so that I can justify that on the record. And that's when I was contacted with with requests for, recommendations on that, and that's when I got the fellows involved.
So when we came in, he'd already had a psychosexual evaluation done for this case. This is a guy who does a lot of these for the court system. But he deemed this kid very high risk, and essentially was like, he needs to stay in custody as long as he possibly can, sort of thing.
He has no letters after his name. That's so what the judge said specifically when she asked for new evaluations and new stuff is, I would like somebody with letters after their name. That's why I phrased it that way. Those were her words.
That said, we still had this mental health report by someone that we essentially had to refute without saying this is a crappy report, and so that always makes it harder as a forensic evaluator to come behind somebody who said something else. So we reviewed the report he had, which was largely based on the report of his mother. So this is the mother who has been in and out of his life, had him around these boyfriends who punch holes in the wall, been neglectful of him, and really was probably trying to cover herself because she looked really bad and not lose custody of her other kids, which she eventually did lose custody of all of them. So she really painted him as this monster, and the forensic evaluator, or the evaluator, didn't talk to anybody else but the mom. So it was a very skewed report in that way. It also didn't include any objective testing of sexual interest. So those were things that we had in mind going into the case. So we went through that report. We talked to the child, we talked to the aunt, we talked to mom, we talked to dad, we reviewed his school records, we reviewed all of the prior mental health records that we had, and we did psychological testing that looks at sexual interest as part of our evaluation of him. And it was true, he'd been in between homes, all these different environments, but it was clear, and all of the adults actually agreed on this, that when he was with dad, he did okay. He did better in school, he had less behavioral issues because dad was structured and stable. He did have a history of using marijuana. Mother had a prior diagnosis of bipolar, he had a brother with a diagnosis of ADHD. And he did talk to us about what had happened to him when he was 5 years old. So he had never talked to his mom about this, but during one of those stints with his mom, the client said that when he was 5 years old, a neighbor who was around the age of 12 or 13 told him to suck his penis and also anally raped him. And he had never gotten any help or any intervention for it. He denied that he had flashbacks or nightmares or some of the things that you would typically associate with PTSD, but this is where he said he learned to tell people or to tell people to do what he ended up telling his little brother to do. He consistently maintained that he had told his little brother to suck his penis, but he just said he had never done anything else, had any other sexual contact of any kind with his brother, and absolutely denied anything happening with his sister. After the brother did it, and kind of that was a big deal, the sister came out too, still unclear what happened there, but he consistently has denied anything with the sister. During his interview, he was actually it was a very different kid sitting in front of us than the kid who was painted in the psychological report that we read. He was very respectful, very likable, and he too showed a tremendous amount of remorse, particularly around his father becoming ill. He thought that his father was stressed out about him and his siblings, and that was part of why his dad got sick, and he actually started crying so hard we had to stop the interview for a few minutes so that he could regain his composure. So this was not a sociopathic, cold, unfeeling kid by any means. And he was also very bright. So we did the psychological testing. It looks at where people's sexual interest lies, and it records it in a way that's outside of their knowing. And that testing showed that he did not have a sexual interest in males of any age, and it showed that he did not have a sexual interest in pre-adolescent girls or pre-adolescent boys. That doesn't mean that he couldn't have done it, but it did have some bearing on how we stratified his risk for reoffending toward the end. He had been given a diagnosis of bipolar disorder, but it was essentially because he got angry and got in fights with mom's abusive, destructive boyfriends, and he went to a hospital and got labeled, but didn't have any diagnostic criteria for having a manic episode, apart from the fact that he got angry sometimes, but this was a kid with a lot of reasons to be angry. And so we really, what used to be Axis 1, the kind of main mental health disorders like depression, anxiety, ADHD, we didn't diagnose this kid with any of those. He had a parent-child relational issue, and he did not have an interest that we could tell in younger children. And of course, when he's done something like that, that's going to raise his risk level. The biggest predictor of, future behavior is past behavior. So we could not in any circumstance say this kid was low risk. But he did have intelligence, he had an invested father, he had a home where he had demonstrated that he could do better when that structure was provided. He had a history of marijuana use, which would have increased his risk had he continued to use, but could also be a point of intervention to bring his risk down. He didn't have sociopathic traits, and he was open, or at least he said that he was, to therapy and to the treatment that he would need. So based on that, instead of categorizing him as high risk, we actually categorized him as moderate risk and identified the reasons why it would be better for him to be with his father than in custody. That he would be around less delinquent peers, that he would help him continue and strengthen that positive attachment that he had with his father, that he would be socialized in a broader environment, and that he would be able to get the educational opportunities that he needed and had been missing on. And like I said, this was a bright kid who really could have made use of them.
I'll note that Sarah and one of the child fellows both testified, or did you do it at the same time? Both testified in court. The judge was extraordinarily impressed with the report, was extraordinarily impressed with the actual testimony, came back and said both of those things over and over and over again. Ultimately decided at disposition to sentence him, instead of 5 years, to serve 36 months, which was a negotiated agreement. Just 5 years serve. 5 years is mandatory. There was no moving around that upper sort of DJJ commitment moment. To serve 18 months, and he had already served 17 and a half of them. So he then went, and really she was basically just holding him for his DJJ screening. So every time you're committed to the Department of Juvenile Justice in Georgia, you have a screening, so they determine, right? It's not like you're home free after your first 18 months. DJJ owns you for the next 3.5 years. At his DJJ screening, this child was recommended for a residential treatment program for sex offenders. He's doing great there. He says positive things about the treatment he is receiving there, and is preparing. He's got about 6 months left before he completes the program, and then the plan they're working on transitioning is to go back and be reunited with his father. So we ended with happy story. Ish. So with that, we used all of our allotted time, but we have 10 more minutes of bonus time from the last session. And we're happy to take some questions. I can see one right there.
Two.
Yep.
You caught me on guard. I'm going to go back to a slide that you reviewed earlier.
I'll find it.
70%, that's okay, it was just one number. 70% of children in the juvenile justice system have mental health issues. What I want to know is what percentage of those children are evaluated by school officials? And second question is, does there need to be a review of the evaluating criteria which these children are placed in the psychotropic pipeline? And should more attention be looked at behavior modification as opposed to a classification of ADHD and some of these other illnesses?
So, I mean, some of them have been evaluated in school and some of them have not, just like Brenda.
Yes, I did it already.
Brenda had not been evaluated in the school at all. But I work in a public sector clinic that sees a lot of these kids, just the county next door to where Randy is. And I mean, we have to fight with the school to get them to do an evaluation. They drag their feet, they don't want to do it. By the time they finally do it, mom's phone may be off, the kid may be moved, maybe at a different school, the whole process starts over again. So sometimes it's been done. It almost always needs to have been done, but not always. And even when you have people advocating with the parents to try to get them to get it done.
Okay, let me be more specific. There's been a recent revelation that African American males in third grade being targeted for the school to prison pipeline for corrections complex. Okay, and in this targeting process, somewhere, school counselors, guidance counselors, and school psychologists play a role in these children's lives. And if there has not been a determination what percentile of the 70% is being done by the school, somewhere is happening. I just want to know what it is.
So there are two different issues there, right? The 70% is actually not based upon entry diagnoses at all. The 70% data were studies that were done of independent folks coming in and making diagnoses. A lot of them, if you notice, are substance abuse issues that accounts for a large portion of it. I agree with you on school to prison pipeline, on all of the bad things that happen. We have both an underdiagnosis problem and an overdiagnosis problem. There are a lot of kids, right? You take a kindergarten-year-old boy, right? And they're active. That doesn't mean they have ADHD. You have a child in foster care who's had a traumatic experience for them and they are therefore distracted. A lot of those kids get diagnosed with ADHD. They should not. You should figure out with some modifications, with some interventions, if those work, and then when they come out, they don't have a mental health disorder. They were ripped from their home and they're distracted for a moment. There are a lot of kids who are diagnosed with things that they should not be diagnosed with. In school, the school psychologists are generally not diagnosing ADHD. Sometimes they are, ODD, sometimes they are, but usually not. They're calling it an emotional behavior disorder, which just means they have destructive behaviors within the school system that are causing problems. We do need to look deeper into what's going on, what's causing that. I think the bigger issue is forgetting about what's causing it and whether we're diagnosing it and whether we're labeling it. I agree, we need to do alternatives to suspension and alternatives to alternative school, and we need to start doing positive supports within our school system. There's a big movement towards that right now. I think mediation clinics are an excellent idea and one of the solutions. Any restorative justice programs that we can do within our school systems that are different than let's just suspend them, that's great. We actually we're in the middle of our legislative session, and we just had a bill introduced that fascinated me that said, the bill specifically says that we can't suspend 5 and 6-year-olds, which I thought was great, except that I was like, really, we need to write a bill about that. But then, what fascinated me even more was we can't suspend 5 and 6-year-olds unless. And it fascinated me that we needed to write a bill that said we can't suspend 5 or 6-year-olds, and that we had to have exceptions to it, so that we could suspend 5 and 6-year-olds if we really wanted to. And it had something to do with intentional behavior, which does a 5 or 6-year-old intentionally do anything? I don't think so, right? So, yeah, we need a different mindset, and we need to figure out how to do that. I think that is a different question than where we are, which is we have kids who have serious mental health issues, or even less serious mental health issues that could and should be treated in the community. Not necessarily with psychotropic meds, although sometimes with psychotropic meds, and we're not treating them in the community. And because we're not treating them in the community, they are who is in our facilities. Because for the typical upper class child who is receiving treatment, I'll throw in the word white if you want, but for the typical right, that profile who shows up in juvenile court on the exact same charges as my kid, the court says, I'm going to dismiss those charges because there's no need for treatment or services. But on the kid who has no treatment or services because they're not receiving it in the community and there's no hope that they will, the court says I need to intervene in this child's life. And they get involved in that child. And so I actually do think the number of kids is right. And it's because those are the ones we're sending there. Right? We're sending them there because they have mental health issues. Not we're sending them there and we're overdiagnosing them. We're sending them there because of their mental health issues, I would say. Does that answer your question?
Yes.
And briefly, you mentioned psychotropic medications and, is it a real illness or if it can be treated psychosocially. Diabetes can be treated with diet and exercise if it's minor. High blood pressure, cholesterol, the same things. That doesn't keep us from saying that they're real issues. And we see that with kids a lot. Everybody may not need medicine, and a lot of people, if they can make the environmental and behavioral modifications that these kids need, they may not need them. Do you have parents that are in a position and able and willing to do that are able and willing to bring them to therapy every month? Do you have a therapist who's actually well-trained and can do the work with the kid? So what we run into in Georgia a lot, and I'm guessing in Florida as well, is that sometimes medicine is the only thing we have that we can give on a consistent basis that they will actually have access to if they don't have a lot of money and a car and parents with stable lives.
We're actually out of time. So,